Hi everyone, welcome to Beyond the Evidence. This is the channel where justice matters. My name is Marv. I am a true crime fanatic, and I love to dig deeper into the mysteries of unsolved cases. Join me as we search for missing persons, uncover the clues in unsolved murders, follow along with jury trials, and we'll be a voice for the voiceless. I'll share with you the facts, the theories, the clues, the evidence, and the controversies that surround these cases. This is Beyond the Evidence. Good evening, everyone. I was getting ready for bed, and then I'm like, oh, I guess I gotta go live. Too much crap happening. The circus continues. Yeah. And if you don't want to take my word for it, well then, take hers. Becky Patty. I am so over this circus. So we all know that the defense put in some documents today requesting that the case be dismissed again. Well, just about, I don't know, half an hour ago, it dropped that now Judge Gull has canceled the 3-day hearings for this week. What in the hell is going on? This is beyond ridiculous. Beyond ridiculous. If that post from Becky Patty doesn't say it all, this one here, I mean, imagine how frustrated we are. Magnify that by 1,000, 10,000. And that's what these families are going through. And it's really starting to piss me off. I don't want the families to hurt, but they are. And it really sucks. It really does suck. With that, let's see who else here. Rescue all the dogs. Nice to see you. Jinx, how are you? Misty Free Spirit, nice to see ya. Hi, Jill. Welcome back. Let's see here. Andrea's here. Elandra. Hello, how are you? Jean, nice to see you again. So glad you're back. She didn't give a reason for canceling tomorrow's hearing and the next 3 days. Just said she canceled it. That's all. Hi, 50 Shades of Faye. And like I said, you guys, we've been going through this for how long now? This is getting ridiculous. It's beyond ridiculous. I mean, come on. I got to get my documents up here. Because we're going to go through this BS again. Okay. Oh, that's the wrong one. Those are all my other documents. All right. Sorry, I got them downloaded right away, and then had to find them. Oh, hey, bossy. So, as I said, the defense has put in a second motion to dismiss the case. And just a little bit ago, Judge Gull canceled the hearings for tomorrow through the 23rd. So let's see what the defense put in here that made her mad this time. That's all I can think of. So these were dropped today. It says, come now the accused, Richard Allen, by and through counsel Andrew Baldwin, and pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution, Article 1, Section 12 of the Indiana Constitution, and Indiana Code 3534-1-4A11, moves this court to dismiss charges against the accused for destroying or losing exculpatory evidence or potentially useful evidence in violation of the standards set out in Brady versus Maryland, 373 U.S. 83, 1963. In support of said motion, the accused states the following: that on February 7, 2024, the accused filed his motion to dismiss for destroying exculpatory evidence and memorandum in support of said motion. In his first motion, the defense detailed how a February 17, 2017 interview of third-party suspect Brad Holder was destroyed while in the possession of law enforcement, along with multiple days of other interviews. On March 18, 2024, a hearing was held on said matter. At the March 18, 2024 hearing, Steve Mullins, investigator for the prosecutor's office, testified that other evidence was destroyed in 2017, as well as it was purportedly unintentionally taped over. Furthermore, it said March 18, 2024 hearing, the defense tendered Mullins undated reports that purportedly explained how the evidence was destroyed. The prosecution did not tender these reports to the defense until after the motion to dismiss was filed. Also, said reports were only turned over to the defense after the defense requested those items from the prosecutor. On April 2nd, 2024, this court issued its ruling denying the defense motion to dismiss the charges. Since the time of this court's denial of said motion, the defense has learned of other exculpatory evidence and/or potentially useful evidence that the prosecution has not turned over to the defense, is missing, or that the state of Indiana has destroyed. Brad Holder's missing phone extraction data. During a recent deposition of Brad Holder, the defense learned that Brad Holder is pretty sure that he turned over his phone to law enforcement on February 17, 2017. The prosecution has not turned over any data, extractions, reports, or other evidence from Brad Holder's phone. Curiously, on the same day, and at the same time that Brad Holder believed that he turned his phone over to law enforcement officers, his son, Logan Holder, also turned Logan Holder's phone. The prosecution has turned over the data extraction from Logan Holder's phone, but not any data extracted from Brad Holder's phone. While the data from Logan Holder's phone was extracted, law enforcement apparently claim that they, law enforcement, failed to extract data from Brad Holder's phone, even though both Brad, and his son Logan turned over the phones to law enforcement at the same time. Could it get any worse? You extract data from the son's phone, but you don't extract data from the father's phone? What the hell are you doing? Jerry Holman stated under oath at a recent deposition that he believes police just looked through Brad Holder's phone, but encouraged the defense to find out for sure from the FBI. Holman, May 3rd, 2024 deposition, page 6, lines 13 through 15. When asked if he, Holman, would have extracted data from Brad Holder's phone if given the opportunity, Holman was non-committal. Depends on the circumstances. But I think you'd have to ask the FBI what they did. Holman, May 3rd, 2024, deposition, page 6, lines 20 through 25. Finally, after being pushed by the defense, Holman finally conceded that he would have extracted data from Holder's phone if given the opportunity. Same deposition, lines 8 through 12. The defense finds it highly, highly unlikely that law enforcement would take the time to collect both Brad Holder's phone and Logan Holder's phone, but then choose to only conduct an extraction of Logan Holder's phone, especially when Brad Holder was a suspect at that time, and no evidence provided to the defense suggests law enforcement considered Logan Holder a suspect. My question is, how does the defense know that at that time Brad Holder was an actual suspect? Does it say that in those documents? Because if it doesn't, this defense team is blowing smoke up everybody's ass once again. So, if you're the defense team, it better state in those documents, in that deposition, somewhere, that Brad Holder was a suspect. Because I am sick and tired of the defense team. On February 17th, 2017, documents specifically sought by the defense, Doug Carter's emails with the FBI provided evidence that Brad Holder was a suspect within days of the murder, and certainly on February 17, 2017, when Holder interviewed at the Delphi police station and turned over his phone to law enforcement. State Police Superintendent Doug Carter was aware that Brad Holder was a suspect. Even the top FBI agent in Indianapolis, Jay Abbott, was aware that Brad Holder was a suspect on February 17, 2017. Logan Holder was not mentioned as a suspect in these emails. I want to see the emails and what the context is of those emails. Because if it is in there that it says that Brad Holder is a suspect, that's one more thing the police have screwed up on. This begs the question, why would law enforcement take both Brad Holder's phone and Logan Holder's phone, but only extract data from Logan Holder's phone when he was not a suspect, but would not extract any data from Brad Holder's phone when he was a suspect? Well, we all know that Logan knew the girls, one of them very well, right? I would extract the data from his phone before I did it from Brad Holder. He was in communication. Logan was in communication with the girls. They can try to put pieces together by the conversation Logan had with the girls. Now, if they truly suspected Brad Holder, then his phone should have also been extracted. But that's not even the worst part, you guys. Additionally, the defense possesses 101 phone extractions that law enforcement conducted on a variety of other phones, many of which seemingly have little or nothing to do with the murders. Well, my thought about that is you're not going to know if it has anything to do with them until you extract them. 22. This begs another question. Why would law enforcement take the time to extract data from 101 phones, most of which were not owned by suspects, yet would not extract data from Brad Holder's phone when they had his phone in their hands on February 17, 2017, and he was a suspect at that time? Like I said before, if he was truly a suspect at that time, his phone data should have been extracted. Now, the defense believes that the above information provides strong circumstantial evidence that law enforcement did extract the data from Brad Holder's phone on February 17th, 2017, and has not turned it over to the defense. Logic and common sense support this belief. If law enforcement failed to extract suspect Brad Holder's phone data while it was in their hands on February 17, 2017, then the only other explanation would be that law enforcement was completely and utterly inept. Now, after reading all that, what did Holman say? Holman said if you want to know what phones were extracted, to go talk to the FBI. So it's apparent that Delphi law enforcement didn't do the extraction on the phones. The FBI did. At least according to Holman in his deposition. Okay, here's the kicker. All evidence of Brad Holder's second interview with law enforcement is missing. Additionally, Brad Holder testified in his deposition that in addition to law enforcement's February 17th, 2017 interview, which was purportedly accidentally taped over, that law enforcement conducted a second interview of Brad Holder sometime later, probably within a year or two of the first interview. Holder further testified at his deposition that A, law enforcement conducted the second interview at the Logansport police station. B, the interview took about an hour and a half. C, the interview was likely videotaped in an interview room. And D, the interview involved much questioning about Patrick Westfall. After the deposition, the defense alerted the prosecutor's office that the defense had A, no phone dump extraction evidence from Brad Holder's phone, B, no evidence whatsoever in the form of video, audio, reports, notes, or any other type of evidence of law enforcement's second interview of Brad Holder at the Logansport police station. On May 13, 2024, the prosecution advised the defense by email that they cannot locate an interview of Brad Holder at the Logansport PD and have no record of Brad Holder's phone being downloaded. At a recent deposition, when Unified Command Jerry Holman was asked about how the defense could obtain any information about the second interview, Holman said he had no idea. but encouraged the defense to reach out to the Logansport PD to find out. Holman Depot, page 5, lines 20 to 25, and page 6, lines 1 and 2. The defense is not required to locate exculpatory evidence or potentially useful evidence of third-party suspects. That is the requirement of law enforcement. Also, at said May 2nd, 2024 deposition, Brad Holder told a third different story concerning how many times he met victim Abigail Williams. 2 times. And that one of Brad Holder's meetings with Abby Williams took place at Patrick Westfall's home. Oh my God. When Jerry Holman was confronted with Brad Holder's ever-changing stories concerning how many times Brad Holder met Abby Williams, Holman stated, perfectly reasonable in my opinion, that he remembered somebody insignificant. If you've only met them twice, you may not remember that. So I don't see exactly what you're asking me. Holman, Depot, page 4, lines 1 through 15. Emphasis added. That's what it says. My goodness. When Holman was asked if it were likely that Brad Holder would not remember meeting Abby, when Holder was asked 3 days after the murders at his February 17th, 2017 interview, but then 7 years later he would remember meeting Abby twice, Holman responded, probably, yeah. Lines 16 through 21 of page 4 of the Depot. Holman showed no curiosity nor interest whatsoever about why Holder's stories have changed. This attitude supports an argument which defense will later make in a motion that law enforcement have acted intentionally or in bad faith to conceal evidence to such a degree that they cannot even admit obvious factual inconsistencies that point the finger at third-party suspects. Now, hey, I give the defense this, okay? There's obviously something wrong with law enforcement. Okay. You don't remember that a second interview was done? Really? Aren't you coordinating all this? You're the head on this case. You didn't ask somebody from Logansport to interview this guy? You don't remember? What the hell? And Holman's answers are sus. I'm just going to say it. They are sus. 36. Patrick Westfall was interviewed on August 17, 2024. Now let that sink in. It's May. We're looking at about 7 months ago, right? Okay, 9 months ago. So he was interviewed on August 17, 2024, and law enforcement extracted data from his phone. The phone extraction shows that Westfall's phone had no data prior to August 11th, 2023, which was the day that law enforcement contacted Westfall and asked him to come in to be interviewed 1 week later. All right, Andrea, you got it. Another typo. So I'm not kidding you guys. Right here, it says Patrick Westfall was interviewed on August 17th, 2024. August 17th hasn't come yet. It's only May. So what they meant to say was 23. And this is exactly what they're saying. The phone extraction shows that Westfall's phone had no data prior to August 11th, 2023, which was the day that law enforcement contacted Westfall and asked him to come in to be interviewed 1 week later. So where did all that information go on his phone? He wiped it. Why would you wipe your phone if you had nothing to hide? That's exactly what the defense is going to say in the trial. Mr. Westfall, why is there no information on your phone prior to August 11th of 2023? Did you wipe your phone to get rid of all the information on your phone? Well, why did you do that? What was on there that you're trying to hide? In other words, it appears that Patrick Westfall either erased all of the phone data on his phone or purchased a new phone after police contacted him on or about August 11th, 2023. The only data found on Westfall's phone was between August 11th, 2023, on or about when police contacted him, and August 17th, 2023, when he was interviewed. No text, videos, photographs, email messages, nor any other data existed on Westfall's phone before the day that police contacted Westfall on August 11, 2023. Did he go buy a new phone? What did he do with that phone that he had? Did he throw it in a river? Is that what they were looking for? Okay. When Jerry Holman was confronted with the fact that Patrick Holder likely erased, do you see the mistake? I just read it. When Jerry Holman was confronted with the fact that Patrick Holder, supposed to be Patrick Westfall, likely erased, attempted to hide his phone data from the state police, Holman claimed that he found nothing unusual, stating, "People erase things all the time." Later, Holman stated that he found nothing suspicious about Patrick Westfall deleting, concealing his phone data before his August 17th, 2017 interview. Are you sure he's part of the police department? What the hell is that all about? Yes, we know people delete their phones when they have something to hide. But how can you, as a police officer, state that you found nothing suspicious about that? Again, Holman's attitude towards third-party suspect Patrick Westfall supports the defense's position that law enforcement has intentionally destroyed evidence or acted in bad faith, or have intentionally not provided missing evidence, such as Brad Holder's second interview, as well as other items identified in this motion. Well, once again, you're saying that they don't have Brad Holder's second interview, and you're saying that there's no extraction information from his phone. I don't know, Bossy. Is this factual or defense hearsay? Could be a little bit of both. That's the problem when reading this stuff. You don't know what is factual and what isn't. At his August 30th, 2023 interview, State Trooper David Vito did not even ask Brad Holder if he, Holder, would allow state police to extract data from his Holder's phone, even though it is clear that Holder had brought his phone with him to the interview. Well, of course he's going to bring the phone with him to the interview. Who doesn't? Dumbasses. Sorry. Therefore, it is not known whether Holder similarly hid erased data from his phone like it appears Westfall hid erased data from his phone. That's a stretch. That is a big stretch, guys. If the data wasn't collected, it's not up to Holder. It's up to police. And to assume that he erased things from his phone, you have no idea of that. You have no facts on that. None at all. So that should not have even been put in here. It certainly is curious as to why Vito did not request Holder's phone data when Holder brought his phone to the August 30th, 2023 interview. Well, if police thought the FBI did the phone extraction earlier in 2017, why would Vito ask to do it again on Brad Holder's phone? Simple question, you guys. Does that make sense? Does that make sense? If police are saying they thought an extraction was done on Holder's phone in 2017, why would Vito ask him to do it again? They should have already had it. But they can't find it. It's also curious as to why Vito failed to ask Brad Holder one single question about Elvis Fields. Maybe it's because they didn't feel that Elvis Fields was credible. It is also curious as to why Vito failed to ask Brad Holder one single question as to the incriminating statements that Amber Holder attributed to Brad Holder that are detailed in Frank's one. Jesus criminy. Vito's failure to ask such important questions to Brad Holder during the August 30th, 2023 interview supports the defense's contention that law enforcement is acting in bad faith. Nobody said Delphi law enforcement was smart. Have any of us said that? Anybody in the chat? Has anybody said that? Because I'm pretty sure we have all condemned Delphi law enforcement on the way they have handled this case. You've never seen me upset? Oh, this case is doing it. Frosty says never. Nope. Telling you. And if I am this upset, now you know why Becky Patty put out a fake Facebook post that said, I am so sick of this circus. Because if I'm this mad, I can just imagine how mad she is. That is one feisty woman. And I know for a fact, I've heard her speak, and I can just imagine the emotions and feelings and disgust that she is going through right now reading this stuff. I agree with you, Bossy. Oh, I've seen. Oh, yeah. Okay. Let me keep reading because we got a lot of pages. But I was looking for my vape. But let's see what other kind of rubbish they say. Mimicked crime scene image found on Brad Holder's social media is lost. What? I'm sure one of us can provide it to the freaking defense. In addition to Holder's 2017 missing phone extraction and missing evidence of Holder's second interview at Logansport Police Station, as well as Holder's taped over first interview from February 17th, 2017, another key piece of evidence is also missing. The mimicked crime scene photo that was on Brad Holder's social media pages. Does anybody have that photo? I'm sure we can send it to the defense. Yeah, it's not lost. It's all over the internet. Exactly. Someone had the photo a few months back. Yeah. Troll shovel. I know who you are. Hello, hello. Trooper Purdy viewed this mimic crime scene image on Brad Holder's social media page sometime in the spring of 2017, along with half of the other country, half of the country, because they were looking at that time. Okay, Trooper Purdy viewed this mimicked crime scene image on Brad Holder's social media page sometime in the spring of 2017. This image was marked as Exhibit F in Purdy's depot and discussed on pages 79 through 81. This mimicked crime scene image found on Holder's social media page holds an eerie similarity to the actual crime scene. In the mimic crime scene image found on Holder's social media page, the bodies of two women appear to be staged, laying on the ground in the woods with branches laid over their bodies. One of the women in the mimic crime scene image found on Brad Holder's social media page has her arms staged, positioned in a similar manner as one of the victim's hands were staged, positioned in this case. At the time that Trooper Purdy observed the mimic crime scene photo on Brad Holder's social media page, the general public did not have knowledge of the appearance of the crime scene, the positioning of the bodies on the ground in the woods, or that branches and sticks were arranged on the bodies. Well, no, we didn't know because you're the ones that told us about it in your motions. In an April 12, 2017 report from Trooper Ryan Winters, it was learned that the state police also came into possession of said mimic crime scene image through an internet sleuth named Ryan Boucher. Boucher alerted Winters to the disconcerting images on Brad Holder's social media pages and then sent said images to Trooper Winters over the internet. On April 12, 2017, Trooper Winters then shared with Jerry Holman his Winters knowledge of the mimic crime scene images found on Holder's social media pages and other information. Hang on 1 second. Okay, my son. Because of the similarities between the images that Boucher sent Trooper Winters from Brad Holder's social media and the crime scene, Trooper Winters requested that Brad Holder be re-interviewed. Despite that request, state police ignored Trooper Winters and never re-interviewed Brad Holder. Now, I want you to catch the key words here, you guys. State police ignored Trooper Winters, not Delphi law enforcement. State police. So they never re-interviewed Brad Holder. Brad Holder was only interviewed in August 2023 after Jerry Holman was challenged by the defense to reopen the Brad Holder investigation. To this day, the prosecution has failed to turn over the mimicked crime scene image that Purdy found on Holder's social media in 2017. So let me ask you guys this. If ISP got all of this information, okay, and did not turn it over, isn't that ISP's fault? Not Jerry Holman's, not the prosecutor. And then my question is, why is ISP not turning everything over like they're supposed to? Delayed, fill the public with false information when they buy the book. Yeah. No. No, it doesn't change their suspect. Is ISP part of the unified command? ISP wasn't in that little building that they purchased. It was detectives and stuff, but I don't know that ISP was in there. Yeah, I did go over that. I showed her post. I like this. How could state police lose an important piece of evidence as an image found on a suspect's social media that mimics the crime scene? How could the two of you be such flippin' idiots? That's my question. It happens all the time. State police, it doesn't matter. Lose things, mismark things. You name it, they've done it. The defense again would proffer that the mimicked crime scene photo was not lost. No, it's not lost, because I'm pretty sure if you ask a bunch of sleuthers out there in the internet, about 20 billion people probably could provide it to you, because they got it screenshot somewhere. Logic and common sense dictates that such an important piece of evidence would not be lost by state police. Yeah, right. The defense's filing simultaneously herewith its memorandum in support of its second motion to dismiss, based upon newly discovered, destroyed, and or missing exculpatory evidence. As detailed in this memorandum, if the defense can show that the missing evidence is exculpatory in nature, then the defense does not need to show that the missing evidence was intentionally destroyed. If, on the other hand, the defense cannot show that the missing evidence was exculpatory in nature, but can show that the missing evidence is potentially useful evidence, then the motion to dismiss should still be granted if the defense can show that law enforcement initially or intentionally or acted in bad faith regarding the destroyed or missing evidence. Currently, the list of missing evidence that the prosecution has not turned over to the defense includes the following: video of Brad Holder's first interview from February 17th. Blah, blah, blah. How many times are you going to say that? Video of Logan Holder's interview from February 17th. Data from Brad Holder's phone extraction from February 17th. Video from Brad Holder's second interview with law enforcement taken at the Logansport police station sometime in 2017 or 18. Audio taken from Brad Holder's second interview with law enforcement taken at Logansport police station. Well, if you're asking for the video, wouldn't the audio automatically freaking come with it? Dummies. Any reports, notes, or documents concerning or referring to Brad Holder's second interview at the Logansport police station. Mimicked crime scene photo observed by Trooper Purdy on Brad Holder's social media page. Images Ryan Boucher sent to Trooper Winters on April 12, 2017. Notice that all missing items are related to third-party suspect Brad Holder. Also, oops, I should probably share this, huh? Also note that the prosecution is asking that the defense not be allowed to even mention the name Brad Holder during trial. Currently, the list of evidence that the prosecution failed to turn over to the defense until the defense requested the prosecution to turn it over, really? Or upon the prosecution's realization that the defense would soon be learning about the existence of said evidence, includes Todd Click letter and accompanying 85-page report. The prosecutor held on to this evidence for over 4 months until he knew the defense would learn of its existence. Don't you have that report now? So it's not missing. Okay. Multiple Elvis Fields interviews. Multiple Johnny Messer interviews. Multiple Taylor Hornaday interviews. Ned Smith interview. Libby German phone dump. Notice that all items AG in paragraph 69 above are related to third-party suspects and Odinism. Oh my God. Also note that the prosecution is asking that the defense not be allowed to even mention any of these third-party suspects or Odinism during trial. The evidence that the defense does have in its possession showcases that on multiple occasions, third-party suspect Brad Holder has changed his answer concerning a very basic question. How many times has he met Abigail Williams? Okay, you tell me right now, audience, those in chat, how does that question point guilt to Brad Holder? He messed up on the number of times he met her. How does it point guilt? Exactly. Odinists are innocent until proven guilty, just like Richard Allen. According to the only police report that memorialized Brad Holder's accidentally destroyed first interview, Holder stated that he had never met Abby Williams. At the time that he was first approached by law enforcement, February 17, 2017, and asked that question, how many times did you meet Abby Williams? Common sense would dictate that the answer would be fresh in Brad Holder's mind and easy to detail because of A, the proximity in time that Brad Holder's son dated Abby Williams. Logan Holder was dating Abby Williams at the time of the murders, and B, the enormity of the situation, i.e., 2 girls had been murdered, one of whom dated Brad Holder's son. I can honestly tell you as a parent, I have not met all of my kids' friends. And up until a little while ago, I didn't even know a certain someone had another significant certain someone. So is it possible for a parent not to meet a friend or girlfriend? Yep. If Brad Holder is in any way involved in the murders, as the defense believes, the evidence strongly supports, then Brad Holder's claim close in time to the murders that he never met Abby Williams is understandable. No, it's not. Denying that he, Brad Holder, had ever met Abby Williams could, in Holder's mind at least, cause the police to take their attention off of Holder. No, it wouldn't. Your son is dating this girl, you're going to be looked at, whether you say you've met her or not. Automatic, in my book. If at his February 17, 2017 interview, Holder was telling the truth that he never met Abby Williams, then his answer to police when asked the same question over 6.5 years later on August 30th, 2023, should easily be the same, I never met her. Because a father would definitely remember if he had ever met his son's girlfriend who had been murdered. Conversely, a father would know if he had never met the murdered girlfriend of his son involved in a high-profile case. What if he met her before Logan and her started dating and had seen her around with Logan but didn't know that they were dating? That is a possibility. The defense is reaching here, you guys. Oh, it's okay, Down Under. I'm just going off on a tangent. I still got 9 more pages to tangent on, so you're okay. However, if at his February 17th, 2027 interview, Holder was not telling the truth as to how many times he met Abby Williams, then it may be difficult for Holder to remember what lie he told law enforcement 6.5 years earlier, February 17, 2017, when he was re-interviewed on August 30th, 2023. For those of you who watch trials, how many times has a witness changed their answer? Initially, they say something. I didn't meet her. Next time they were interviewed, oh yeah, I met her. Because they remember it after thinking back on it. It happens all the time, people. Okay. At his August 30th, 2023 interview, Brad Holder's story changed. Now he claimed that, in fact, he had met Abby Williams one time. Okay? Like I said, it is not uncommon for witnesses' stories to change. Either Brad Holder intentionally lied to police in 2017, closer in time to when Logan dated Abby, or Brad Holder had simply forgotten his meeting with Abby Williams, but then somehow remembered that meeting 6.5 years later. It is possible, especially when everybody's talking about the case and your son dating this girl. It's very possible. Then, at this May 2nd, 2024 deposition, Brad Holder provided yet a third different answer. He actually had met Abby Williams 2 times. Furthermore, at this May 2nd, 2023 deposition, Holder remembered that one of those meetings occurred at Patrick Westfall's house. Holder Depo, pages 20-21. Brad Holder's ever-changing answers to such a simple question provides evidence that the missing items, A through H, detailed in paragraph 66, are exculpatory in nature. When combined with the evidence contained on Brad Holder's social media pages, including images of rune inked onto Holder's hand that mimics the way sticks were formed on Abby's body, as well as all the other evidence detailed in Frank's 1, the ever-changing stories of Brad Holder on the simple topic of how many times did you meet Abby Williams should all provide insight into why the defense believes that the missing evidence contained obviously exculpatory evidence. How could it not? Well, my question for you, Mr. Lawyer, is what evidence do you have that Brad Holder did it? Because you can't tell me just because he changed his answer about meeting Abby no times, 1 time, 2 times, makes him guilty. So what is it? It would be possible for the defense to show that the missing evidence contains clearly exculpatory evidence. Therefore, the defense is left with providing circumstantial evidence along with logic, reason, and common sense as to why the many missing items would contain obvious exculpatory evidence. You're reaching, defense. You are so reaching. The defense believes that it has shown that the missing destroyed evidence is exculpatory in nature. Oh, good God. The missing destroyed evidence is exculpatory, but even if the court disagrees, the court should find the missing destroyed evidence as potentially useful and dismiss charges. As detailed in the accompanying memorandum, if this court finds that the missing destroyed evidence is not exculpatory, but does find that it is potentially useful, then the court should dismiss charges if it also finds that law enforcement intentionally caused the potentially useful evidence to be destroyed or acted in bad faith regarding the missing evidence. Frank's 1 through 4 provides many details of why this court should believe that law enforcement intentionally caused the potentially useful evidence detailed herein to be destroyed or acted in bad faith. The defense incorporates the contents of Franks 1 through 4 in this motion, like she hasn't gotten the first 3 copies. Provided below are a few facts that support the defense's contention that law enforcement has acted in bad faith or intentionally lost or destroyed evidence or have failed to turn over said evidence to the defense. Missing portions of vital video from Jerry Holman's 10/26/2022 interrogation of Richard Allen. Jerry Holman interrogated Richard Allen on October 26, 2022, and said interrogation was videotaped. However, the first few minutes of the interrogation are missing. The missing portions of the video, according to Jerry Holman, would have shown Holman discussing Richard Allen's Miranda rights and freedom to leave the room, both important concepts that might support the legality or illegality of Holman's interrogation. No explanation exists as to why the only portion of the videotape interrogation that is missing is the crucial beginning of the interrogation. The missing video supports the defense contention that Holman knew he had screwed up and therefore edited out the first few minutes of the interrogation to avoid the statement being suppressed. Okay, what did he do in the first couple minutes that was so bad that he deleted it out? Any thoughts? Because the first couple minutes is usually chit-chat about why he's there. The missing video from Holman's October 26th interrogation of Richard Allen is evidence of intentionality of law enforcement involving the concealment or destruction of evidence and or evidence of bad faith. And we thought we were bad at coming up with stuff against the police department. We got nothing on these guys. Nothing. Jerry Holman lied in his August 10, 2023 deposition that Brad Holder was never a suspect. In his August 10, 2023 deposition, which asked if Brad Holder was ever a suspect, Holman said the following: "Not really. No." However, it is clear from reviewing emails between Doug Carter and the FBI that Brad Holder was a suspect very early on in the case. Well, defense team, could it be that Brad Holder was a suspect of the FBI or by Indiana State Police, but not Delphi Police? Yes. I mean, come on. FBI said Ron Logan did it in the search warrant. Right? Yeah. As stated before, Holder was thought to be a suspect, and his name was known as a suspect even at the highest level of the state police, Superintendent Doug Carter, and even known to Indianapolis's top FBI agent Jay Abbott. The fact that Holman misled the defense by claiming that Holder was not really a suspect is evidence of the intentionality of law enforcement involving the concealment of evidence and or evidence of bad faith. Not if they didn't think he was a suspect. I mean, come on. FBI thought he was a suspect. Great. ISP agreed that he could be a suspect. Great. But Delphi law enforcement didn't think he was a suspect. So that means they're lying and covering things up? No, just makes them dumb for not looking into it in the first place. The prosecution failed to turn over Todd Click exculpatory evidence for 4 months and then only turned it over after it was obvious that the defense would be learning of the existence of the Click letter. Good God. As detailed in Frank's 1 and numerous other pleadings, the prosecution chose to not turn over exculpatory evidence from May 1st, 2023 until September 8th, 2023, of a letter from Todd Click in 85 pages detailing his investigation. Contained in the Click letter was evidence that 3 law enforcement officers, blah, 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 we've heard this story all the time, yada, yada, they believe the third-party suspects, Brad Holder, Patrick Westfall, and Ellis Fields were involved in the murders. But the defense never says what evidence they had that they were involved in the murders. Believing they were involved in the murders and actually proving they were involved in the murders is 2 different things. And Click's belief that the evidence supporting their involvement in the murders was much more compelling than the evidence against Richard Allen. Then tell us what that evidence is, because you tell us everything else. So you might as well put it in here and tell us what that evidence is. As stated in a previous pleading, it's hard to believe that a much stronger example of exculpatory evidence could exist than documentation that 3 law enforcement officers essentially believed the wrong man may have been arrested. And yet the FBI, that lady, was convinced that Ron Logan did it. The fact that the prosecution refused to not immediately turn over the exculpatory Click letter for over 4 months is evidence of the intentionality of law enforcement involving the concealment of evidence or evidence of bad faith. The prosecution failed to turn over exculpatory evidence contained in several videotaped statements until after the prosecution knew that the defense would soon learn of their existence. As detailed earlier in this motion and in Frank's 1, the prosecutor failed to turn over several videotaped interviews that provide exculpatory evidence concerning third-party suspects until after it was clear that the defense would soon be learning of the existence of those videotaped interviews. Is it just me, or could they have summed this all up in like 4 to 5 pages instead of 20 because they just keep repeating themselves? The prosecutor turned over these videotaped interviews nearly 9 months later than required under law, under rule and statute. Those videotaped interviews provided exculpatory evidence in terms of blown alibis of third-party suspects, as well as connectivity between third-party suspects, and also probable, I'm not kidding, probable lies told by third-party suspects concerning their knowledge of other third-party suspects. Oh, I love the spelling errors. Thank you, Alondra, for the super sticker. This is a big show. Oh, you sent another one earlier. Thank you so much. I appreciate it. Okay. At the August 10th, 2023 deposition, Jerry Holman stated under oath that part of the reason that law enforcement ruled out that persons practicing Odinism or some type of cult had committed the murders was because a Purdue professor had ruled out such a possibility. However, after reviewing the Purdue professor's report prepared on or about March 1st, 2017, as well as listening to the Purdue professor's September 19th, 2023 interview, it was determined that the Purdue professor never made such a claim as Jerry Holman stated in his Holman's deposition. Well, we can only take the defense's statements as this is a fact because we haven't seen any of that. Furthermore, at his deposition, the Purdue professor, Jeffrey Turco, specifically denied that he had ever made the very statements that Holman attributed to Turco. Additionally, the prosecution told the defense in September 6, 2023 email that the identity of the Purdue professor was still unknown and may not ever be able to be found. This was untrue as Jerry Holman had already learned of Jeffrey Turco's name weeks earlier. Additionally, the defense learned that the actual Purdue report from March 1st, 2017, which also contradicted Holman's deposition testimony, was in the possession of law enforcement since that time, but was not purportedly rediscovered by law enforcement in August 2023. The prosecution finally produced said report to the defense on October 4th, 2023, and only upon request of the defense. And that's because the prosecutor probably said, listen here, assholes, you have this information, find it, and give it to me so they get off my back. I will read all your comments, I promise. Jerry Holman's August 10, 2023 deposition testimony was false concerning the findings of the Purdue professor, and therefore his testimony is evidence of law enforcement's intentionality in attempting to conceal evidence and/or evidence of bad faith. The attempt of law enforcement and the prosecutor to conceal the identity of the Purdue professor is further evidence of intentionality in attempting to conceal evidence and/or evidence of bad faith. Like I said, they love to repeat themselves over and over again. Okay. The prosecution failed to turn over one of the key pieces of evidence for nearly 9 months, and then only after the defense kept requesting the prosecution for the same. A key piece of evidence in this case is the phone data extracted from victim Libby German's phone. The prosecution and law enforcement had possessed that evidence for 5 years prior to Richard Allen's arrest, and therefore should have been able to provide the evidence immediately to the defense. However, the defense did not receive that evidence until September 8, 2023, almost 9 months later than required under criminal rule. After the defense had a chance to review said data from the phone, it was determined by the defense, in the way that they viewed things, that exculpatory evidence existed in the phone that did not support law enforcement's timeline and supports that third-party suspects were involved in the murders. The failure of law enforcement to turn over Libby German's phone for nearly 9 months, thereby concealing exculpatory evidence the defense could have been exploring from the beginning of their representation, is further evidence of intentionality in attempting to conceal evidence and/or evidence of bad faith. Good God. I'm not going to read through all this because it's all the same crap. Law enforcement concealed the blocker report until April 26, 2024. So basically they're saying State of Indiana turned over a report from Steve Mullen concerning the findings of Sergeant Mitch Blocker. Containing in the body of that report was exculpatory information concerning ping information that supports that on February 13th, 2017, the victims were not located at the same scene as they were found on February 14th, 2017. So basically, they're saying that the bodies were not there on the 13th. And they say they can prove it. Let's go on to the next one. Tobled Zimby contradicted the sworn testimony of both Jerry Holman and Tony Liggett concerning the number of people involved in the murders. This matter is detailed in Frank's 1. Yep, we know it. Both Liggett and Holman testified under oath that only one person, Richard Allen, was involved in the murder of the victims. This proclamation under oath by Liggett and Holman would negate the defense's contention that evidence supports that multiple people involved in Odinism were involved in the murders. However, when Tobe Lesenby was deposed, Lesenby stated under oath that Tony Liggett actually believed that multiple people were involved in the murders. This conflicting sworn testimony of law enforcement is further evidence of intentionality on the part of law enforcement to conceal their actual beliefs concerning the number of people involved in the murders of the victims, in order to direct the defense away from theories that Odinists were involved in the murders. No recordings of Richard Allen's interview with Dan Doolin exists. Well, that is a problem. I would like to know what he said to Dan Doolin. In 2017, Dan Doolin had stated that Doolin knew that he had audio recorded interviews when conducting interviews of tips and leads. Doolin claims he now believes that he never audio recorded his interview of Richard Allen. I think I must not have audio recorded it because all the other ones that I had are in a file on my computer. And I listened to each of them just in case they were mislabeled. Every audio recording I have, and none of them was Mr. Allen. This interview is crucial as what Doolin claims Allen told him helped establish the timeline used to secure a search warrant and to arrest Allen. So the fact that Richard Allen placed himself there, yep. That he was wearing a jacket and jeans like BG, yep. And that there was a bullet found that matched his gun. Well, Allen wouldn't have known that at the time he was giving the interview. So basically, he was putting himself there. So with that information and the fact that they had the bullet, they got a search warrant. Don't need to have that recording. The defense believes that Richard Allen was tape recorded and the missing tape supports intentionality on the part of law enforcement and/or evidence of bad faith. So basically, what they're saying is that any evidence that supports a third party, the prosecution, law enforcement, state police, and the FBI have all erased and got rid of just so it doesn't have to go to the defense. Really? Then they go over the missing mimicked crime scene images again, which is a crock of shit about Brad Holder being third-party suspect. Yet Jerry Holman denied that fact, and then law enforcement failed to turn over multiple pieces of evidence. And his initial interview was taped over. And then I'm going to cry because they never extracted data from his phone, but they extracted data from 101 other phones that didn't even have anything to do with the murders. And why would you extract phone data from the son and not the father? That's what they're saying in here. I'm just ad-libbing and shortening it a lot. And this mimicked crime scene photo was given to police, and now they can't find it. Richard Allen cannot have a fair trial when exculpatory evidence that would support the involvement of third-party suspects is missing. Only so many coincidences can explain away why so much evidence concerning Brad Holder and Odinism is still missing, and why the prosecution failed to turn over much of the evidence that the defense does in fact possess concerning third-party suspects for 9 months or more, and only after the prosecution knew that the defense would soon be learning of the existence of that third-party suspect evidence. Thank God, we're on the last page. The bad faith of law enforcement and prosecution has been proven through these numerous examples of missing evidence and evidence that the prosecution failed to turn over to the defense in a timely manner. Because the missing evidence is exculpatory in nature, the charges against Richard Allen should be dismissed. Even if the court finds that the missing evidence is not exculpatory, it is clearly potentially useful evidence, and the numerous examples of bad faith contained in this motion require that charges against Richard Allen be dismissed. Wherefore, pursuant to the law detailed in his memorandum in support of this motion, as well as the facts contained in this motion, the defense requests this court to dismiss all charges against Richard Allen. You know what I think they should do? Here's what I think they should do. I think Judge Gull should dismiss the charges. And then I think that the police should go rearrest them, get a new judge, new defense attorneys, and then the prosecutor's got all this stuff now. Give it to him right away. Just give him all to it and see what the new defense team thinks. How absurd is that? Y'all know I was just joking, right? Well, I was joking about the part of dismissing the charges. You got that right, 50 Shades of Faye. Mercy. Everything is exculpatory except things like Odinite's alibis and one is work. Down Under says it as if that's going to happen. We are here for you. Yeah. Let's see. I hope I don't get subpoenaed. Her pitch is getting higher. Yes, it was. R.A. is a creep. The girls MS interview that worked with him are telling the truth. I know firsthand that bathroom was closed off and he would watch employees from the end of the aisles. Marv had it at the beginning. That's unfair. You can't accuse the accused in a court of law. I've been waiting for that info with zero patience. That's what I want to know. What was found? I'm telling you guys, They are not going to go arrest a man just because he was at the scene the same time the girls were. He wore similar clothing, and there's a bullet that they say matched his gun. There is no freaking way they're going to take the chance of an acquittal on just that. They have more evidence. What is it? We all are dying to know. And now we got to wait till October. We don't need it. We have Bridge Guy in the timeline, video, and evidence seized. Attack the evidence. Show the public instead of leaking stuff we knew for years ago. Exactly. Exactly. Fifty Shades says, I think it's as simple as I was there and I saw 3 girls and I did it. Let's say the bodies weren't there on the 13th. That automatically means RA didn't do it. Motorcycle cover could come into play if it's legit. Exactly. I don't know if they did or no, I don't think they ever asked for RA to be put into general population. The whole reason he's in a prison is so that he isn't around anybody else. All these people scream and send him to a safekeeping like an apartment, live nowhere near him. If they do, then they're idiots, but we know they wouldn't want him anywhere near their families. Right. It's all a game to them at this point, which stands to reason they feel not responsible for their own client. I think D is trying to delay and prodding the judge and prosecution with hope one of them will make a mistake catastrophic to the case, all while building motions for the appeal already. I agree 100%. And I think that is why, getting on to the second part of today's topic, that is why Judge Gull is not having hearings. She doesn't want to deal with the bullshit from the defense. She's just denying everything. And now she's canceled the hearings for tomorrow through the 23rd because of this crap. Now, does that make her biased? I don't know that it makes her biased. I think there are certain hearings she needs to hold. Absolutely. But I think the first thing she has to do, which I have not heard, so correct me if I'm wrong, she either has to recuse herself or deny their request to recuse herself. She can't do anything until that is taken care of. And yes, he's confessed. Not once, not twice, not 3 times, not 10 times, not 20 times, over 30 times he has confessed. 2 different people. That's huge. A bullet, they asked specifically if there's any reason it would be found out there. He didn't say, oh, I hunt there. He said no. He also said that he doesn't let anybody else use those guns. That confession must match the evidence and crime scene. Something does. Prosecution definitely has some doozies coming. Oh, yeah. He doesn't deserve protective custody. Fend for yourself like the rest of us have to. Yeah. They want him dead so they can sell their book, Hearsay in Delphi. Then the follow-up, he said, she said, yep. They don't want the prosecution's evidence to come out. That was worded very well. The people using Delphi and Florida to push their political agendas are vile, apathetic humans. The universe doesn't miss anyone, and I feel bad for your karma, honestly. Um, all right. Going back up here. A couple weeks ago, I started believing the defense has very little in terms of a legit defense. The filings from last week and today just cement that theory. I agree. When you don't have anything, what is the defense that you go with? Third-party defense. And like I said as I was reading this, where is your proof, defense team, that Brad Holder, Patrick Westfall, and Elvis Fields actually did this? Anybody can say they did it, but where's your proof of it? Has anyone actually looked up Anthony Garcia, whose defense diaries always goes on about they messed that case up, one got suspended and the other was nowhere to be seen until sentencing? I don't know if I've heard of that one. And clever alt name, you can jump in late whenever you want. I don't mind. Wasn't R.A. Alibi his wife, but in 2022 they found out she was out of town? I do know for a fact, and I don't think any documents have stated for a fact, but we've got months now to do this, and that's my plan. So what I'm going to do coming up, we're going to start back at the beginning as far as the documents. There is information in those documents that I have missed, that have been pointed out to me. So I know that they've probably been missed by others. So we're going to start going through the documents from the beginning till now, and in a PowerPoint. The audience here is going to help me put the key points and evidence in the PowerPoint so we can keep it in one place. And that's going to start the end of this week. Laundra says, sounds like dirty justice system like in the Tabby case. Oh, yeah. You got that right. Thank you so much for your support, Elandra. I appreciate it. Your super chats tonight that you've given, I truly appreciate it. What? Hennessy has some nudes? Interesting. If he legitimately confessed. What makes the defense think anyone is going to believe anything else other than the confession? Especially if it's done 38 times. Yes. Bossy, there's something in that second statement they want thrown out. And it's damning to their case. Absolutely, I believe that. Thanks for running this one, Marv. Well done. You're welcome. Like I said, it was a lot. It was 20 pages, but it was important to go through it. Like I said in the past, you guys too, there are kernels of truth in all of these defense documents. There's a lot of BS, though, too. We've got to be the ones to try to pick out the kernels of truth. Andrea, they hope us to throw him out. I still think he'll plead out. I heard defense has 2 continuances left to use. And defense 1? You mean the prosecution has 2 and the defense has 1? Why else would he defend the defense pro bono? Not like they got a fundraiser going on, right? Have a good night. 50 Shades of Faye. Thanks for coming. Oh, thank you so much, Yolanda. I appreciate it. Mwah. Love ya. The party's keeping me well paid. Good night, everybody. Please join me tomorrow night as I will be giving you an update on Athena Brownfield. Little girl that lost her life in a very, very sad story. And there's been some twists and turns. I might be missing something here, but if Holder's interviews were lost, how do they know how many times he had met Abby? Good question. All right, everyone. You have a good night. I'm getting off here. I have got to go to bed so I can get up and work in the morning. But love you all. Thank you so much for the support. And I'll see you tomorrow. Have a good night. Bye.